what would be the obligations of each side in a very serious earth-shaking case, do you suppose? Is it different than the ordinary case, or is it just different in terms of, is it genuinely different than the so-called ordinary case? Ethically speaking. I was talking with the people, I started the recording, I was talking to the people here that are here live, and bringing up murder case that's still going on. The jury is deliberating. Earth-shaking case, um, one that the outside world cares about rather than just the people in the particular situation that they're in, rather than families and friends of each side. But the ethical obligations are the same for that case as they are for every other case. Yeah, Shannon agrees with me. Shannon Pinnock is here. Lawyer would have the same obligations no matter how big the case. That's true. Um, and in some ways, like I say, those small cases end up being very earth-shaking too. And I probably brought that up before. One young man um, actually was driving a car, and an old man, a pedestrian, um, was hit and killed. And I'm sure the family of the old man thought that it maybe should have been charged with murder, but it wasn't. It was charged as a misdemeanor. And yes, um, the old man was just as dead as if it had been a murder, but it was charged as a misdemeanor. And that was one death case where I represented the defense. Um, Not a huge amount that I could do for the defense side, other than I did um, try to lay some divide the blame a little bit in the eyes of the judge, in terms of the fact that the vehicle was released, should not have been, but was released to my client, my young client, by a different police department earlier that day, even though the windshield was so badly cracked that it was created difficulty seeing. Um, I'm sure that police department that released the car to him out of impound wish that they had just hammered it out of there. No windshield would have been a lot better than having that one. And I was bringing up, and this is a repeat for those of you here, but are any of us operating in obscured windshields during legal work? What would that be? Basically, not looking up the main sources as we try to develop facts in a case. We need to know the main sources. In terms of uh, legal ethics, paralegal ethics, the main sources are to go right to the state law, which in this case is called rules, but rules are laws, okay? And then, of course, state cases. Um, in some cases, federal cases, of course, um, but the attorney-client privilege also beyond cases, beyond rules, also includes statutes. Who knows the difference between a statute and a rule of court? Attorney-client privilege may, depending on the state, may be based mostly on statute or mostly on case law. Work product rule is typically by rule of court and cases. And of course, you want to have the cases in the same jurisdiction whenever possible. But I will allow you, since there's frequently more accessible law federally, and the materials, the lesson content materials, focus somewhat more on federal for understandable reasons, because we work with students in a number of different states. So federal law is okay to use, but make it primary federal law. Rules, statutes, cases. Questions, problems? Who has a insight into an easy way to know the difference between primary and secondary? My typical answer is that primary means it is the law. Secondary means it talks about the law, it explains the law. Who has another insight or help that would help classmates? You're all muted, so you can either unmute or use the chat, please. Appreciate any comments you have. I see some students are totally locked in on the difference between primary and secondary, and other classmates of yours are still struggling with it. It is a different definition legally than it would be outside of the law. If the Chief Justice of the Supreme Court writes an article for the Harvard Law Review, would that article be primary law because he is the highest judicial officer in the land? Yeah, Shannon gave an example. Secondary would be a textbook source about the law, yes. Okay, there's another definition of primary that Heather brought up, and that's different than what I'm talking about, but it's still important. Um, um, from my definition, no cell phones while driving would still be a primary law, even if they're not allowed to arrest for only that. Um, Basically, uh, in my definition that I'm using, which is the same one the course is using, is the normal definition that you use when doing legal research. Is a primary law is anything that is the law. Any statute is the law, whether they can arrest for it or not. And then any rule of court is the law. And any higher court case is the law. Appeals court case. It would all be considered primary sources, okay? Primary sources. Yeah, I'm not really saying primary law and secondary law. What I'm really doing is saying primary source of the law, okay? Secondary, it's sometimes easier with a secondary source. If it's a comment about the law, but it is not the law, okay? Or if it's a model rule or a model law, but it's not the law in any jurisdiction. It's not the federal law and it's not the state law. A model law is not the law. It's secondary, okay? Um, So these are the things you want to accomplish. If anything does not work for you, if any of these things do not work for you, you need to let me know. Attorney-client privilege sounds like it goes both ways, but it doesn't. When I represented something, I didn't own an attorney-client privilege, the client did. Chew on that mentally a little bit. I didn't own it. So let's say that I chose to remain silent because I thought it would benefit the client. The client wanted me to talk in court. I guess the client can rule. But if I have to testify, that puts me in an odd ethical position. Then I have to drop out of being, involved. I also ethically, though, can advise the client that it would be much smarter to exercise the attorney-client privilege and not have me testify. Number one, then he can continue to have me as the lawyer rather than me to say, well, since I'm a witness, I can't be the lawyer. The other advantage is that anything that I say that helps my client in court is going to be discounted anyway because the assumption of the judge is going to be that I am just bolstering my client's case. Do you see where I'm coming from, folks? Does that make sense? But I can't say, oh, I cannot say against my client, well, I choose not to testify even though my client wishes me to. It's not really, it doesn't really work both ways. The work product rule is a strange thing that only makes sense when you realize that almost everything in the world that can relate to a case can be discovered by the opposing party. Almost anything except for our strategy of how we're going to do things. So work product rule only makes sense to people who understand that most things are not covered by it. Work product rule is an exception, not a generality. I'm going to move on in slides, but I will have to explain that. Most of what I'm explaining the work product rule, though, is to try to put it in context. Those of you that have worked as paralegals in law firms involved in civil trials might be a little bit bored as I explained discovery if you've already worked on discovery documents and so on. But sometimes you could work for years, but the lawyers you work for may not explain the overall idea behind everything. You just know that you have to do these things. So some of you experienced people can still get value out of this. And this is the slide from before. If you don't know for sure who runs the practice of law, it's the state's highest court. Nobody else. Primary or secondary? ABA rules, secondary. Not the law. Just advice to states. State's highest court rule, primary source of the law. It is the law. Statutes, primary. It is the law. Articles by attorney, secondary. It is not the law. Explanation. Is this coming clear now? This definition of primary and secondary does not hold true in all uses of these words. These are special source definitions. What kind of a source is it? okay? And there is more than one, and that was brought up by Heather, that there are actual primary laws that are not allowed, they're not allowed to be enforced directly. Okay. It used to be seat belts, and for instance, it used to be in some states at least, they couldn't stop a car for failure to use seat belts, and later on, I think they could in most states. People hated seat belts, and of course, the old seat belts weren't worth too much anyway. Back in the 70s, they put them in, and most people tucked them in the bench. We had bench seats in front, and people would tuck the seat belts to try to get it out of the way because everybody hated them. I bet I'm the only one here that remembers that. Um, this is a background to attorney-client privilege. Usually when you invoke the privilege, you're doing so typically in court or any court proceeding, rather than just sort of generally. So this is how, let's just say the attorney-client privilege is, how is confidentiality maintained during a lawsuit? And assume the context is all context without a clear exception, all facts come out and are revealed, okay? With that context, how is this falling into place for you? The same thing is going to happen when we start talking about the other topic. You need to start with the idea that everything is pretty well discovered. Almost everything is discovered before trial. And then at trial, anything relevant needs to get put out there, okay? Unless it's relevant but grossly unfair, because the unfairness of it outweighs any slight amount of relevance, okay? But there's exceptions to what has to be revealed, and one of them is attorney-client privilege. Any closely related one is work product, but it's not the same. Attorney-client privilege is not the same as work product. The common law provides, what is common law? For our purposes in researching, it's common law is case law. Is case law. Higher court decisions. Okay. Now, some attorneys have screwed up the first part. Think of elements. If the elements are not met, you don't win on things, okay? This is true in legal ethics. It's true in attorney-client privilege. Technically, attorney-client privilege is not just an ethical principle. It's a normal principle of law that has to do with winning and losing cases. But it also, anything that has to do with winning and losing, though, means that the lawyer needs to try to preserve whatever helps that lawyer's client, and then of course the paralegal needs to understand this and try to help preserve it. So if a lawyer is tempted to talk to a client confidentially with the client's cousin there, the cousin not being a person who would normally assist and have to assist with a matter, not an employee of the client, not somebody who works for the law firm, but just a cousin who just happens to be visiting. Oh, I had coffee with my cousin, so now I'm going to have my cousin come and visit with the lawyer confidentially. Well, it's not confidential. The attorney-client privilege has probably been blown in most states. So, number one, um, maybe you should pass a note to the attorney. Um, wouldn't it be better if I had coffee with if I got some coffee and kept the cousin in the waiting room? So in case the client needs to share something that we want privileged. Does that make sense? You see where I'm coming from? You don't want third parties, extra parties in there. Now, if a husband and wife both own a business and they jointly go in and see the lawyer, um, and the communication there is about the business, they both want the lawyer to help, and they agree on, having the lawyer be the lawyer for the business, then of course it is still confidential communication. Would it be a confidential communication if the husband and wife were starting a divorce and they both go in there and talk to the same lawyer, and later on they decide to get their own lawyers? No, I think we blew it. Now, but maybe we didn't blow it, because you would need, if that thing happened, you would need to look it up in the case law of that particular state, because maybe you didn't blow number one. You try to find an exception um, to the normal rule, okay? Uh, One of the rules of research is don't give up so easily. Um, if you are pretty sure that it was blown, try to find a way that maybe it wasn't blown, okay? So maybe number one still applies, because they were, um, their preliminary conversation maybe was privileged. Um, Maybe they were just talking about a business relationship and so on, and something was let slip or whatever, but it was basically a confidential conversation. So you want to find the state law of the particular state. But there have been a number of times, though, when this thing was blown, and basically one and two, lawyer and client, okay? Usually number three is not a problem. It's one and two. Was it truly a confidential communication, or were you blabbing it on the street loud? Was it between a lawyer and client, um, or were you talking to somebody else's lawyer, just shooting the breeze? I mean, people asking me about something. This is interesting because people used to buttonhole me on the way to the post office. I'd go to the bank and, oh, hey, is this illegal? Is this, okay? And of course, lawyers get accused of being indirect and so on. But if you answer the question directly, then um, 6 months later, they'll claim you were their lawyer and that was your advice. Do you see why sometimes lawyers have to be obscure and indirect? Yeah, it seems odd, but um, grocery store, I've been out of active practice now for a few years, but I still get stopped once in a while. Um, but I mean, I can go to the grocery store or the hardware store now. But well, and it's a protection of the client too, because casual advice is bad advice. If you want really, really, really bad advice, just um, ask your relative who is more closely related to the lawyer in the family than you are, and they'll say, "Well, my nephew, well, who's not exactly your nephew, but your nephew-in-law would say that it's okay to go ahead with what you're doing." Bad advice because they don't know the fact. They didn't ask you any questions. If they did ask you questions, they didn't ask the correct questions. Same thing with if you actually did talk to the person that you kind of know who is sort of a relative of yours or whatever, and you ask them at the grocery store, um, don't really give them much facts. Bad advice. Bad advice. So, well, there's no way, um, the lawyer says, there's no way you could garnish them, even if you do have a judgment. You can't tap the bank account. Well, technically, uh, maybe you can't, but maybe you could if you registered the judgment in a certain way in your states, okay? Same thing. Well, I understand you rented out yeah, you told me you rented out your house, and you want to just change the locks so your renter has to leave. Sounds okay to me. And you could get in big trouble and have a big lawsuit if you take that casual advice. Maybe you have to, um, most likely your state may require something like a court proceeding of eviction rather than just change the locks. I mean, uh, curbstone advice can be terrible. Okay. Um, United States versus United Shoe. Like I say, I wouldn't take, even if even the best lawyers I know, their curbstone advice is terrible. Okay? That sounds bad, doesn't it? Um, it's and a curbstone advice is where they really don't know the facts and they don't actually look up the law. They just shoot off their mouths. Even though they're a good lawyer, they're probably giving bad advice. And I'm sticking my neck out saying that because obviously um, some generalized advice may not be terrible, but uh, I'd be real suspicious. Okay. Um, this is the key again. To me, this is the paralegal key. Communication relates to a fact of which the attorney was informed by his client without the presence of strangers. Now, don't use strangers in typical meaning. Okay. What do they mean by strangers? They don't mean strangers. They mean anybody other than um, somebody who belongs to this situation. Okay. So you have the client and attorney, and you have strangers. Not really people nobody knows. A favorite cousin may be a stranger to this legal problem, to the attorney client relationship. An out of town corporate person may not be a stranger, even though you've never met them before. That would be like any business matter. Where the client and the out-of-town person are both part of the corporation. Okay. So it's dangerous to overgeneralize, but everything in here basically you kind of need to think through. Okay. And you have to kind of watch your terminology, just like we needed to really watch your terminology with the primary and secondary, and then with the confidentiality and all of that. We really need to realize that sometimes when judges say stranger, they don't mean it. Okay. Just like alien, what is an alien? What is an alien may be a person from a neighboring state. And a Minnesotan might consider a Wisconsinite an alien uh, when my ball team is playing against their ball team, but only lawyers really mean it when they say mean something when they say alien. Okay. Um, an alien may be somebody from another country or from another state, and stranger doesn't really mean what we normally mean by stranger. So beware of that when you're talking about privilege and confidentiality. So a person's favorite cousin, uh, best friend could be a stranger. Don't go see a lawyer with your best friend and then have the best friend in there during the confidential conference because you may have waived the privilege. Um, on the other hand, uh, let's say that uh, you know in some states you could be working with a an advocate, uh, you know, of some sort. Even there, though, even with like a an advocate who is looking out for a person's physical safety and so on, I would still say to be on the safe side, the client should talk to just the lawyer. Okay. And you would want to do some research before you had, let's say, a um, one of the advocates, domestic abuse advocate, or somebody go in there and talk to the lawyer as well. I would say talk separately to be on the safe side, unless you can find a case decision in your state. Okay. Work product um, provides a zone of protection for case strategies. Note that it says case strategies, not NOT case facts. Um, what if I represented one of the big tobacco companies and I sheltered everything, all of the facts that came to my attention? I sheltered them by claiming that they were work product. What would happen in a civil case? Who knows enough about civil cases to, who's comfortable with what happens? We attempt to shelter all of the facts of the matter as if they were work product. We say we don't have to disclose this to the other side. We can just say it's all work product. It was all prepared by us for litigation, so we don't have to blab. Um, wouldn't that backfire 100%? Because case facts have to be disclosed to the other side. Have to be disclosed to the other side, not concealed. The tobacco companies got billions of dollars assessed against them from lawsuits, and a lot of it had to do with concealment of evidence. But their strategy, they could conceal, and their particular viewpoints and their arguments back and forth. Of course, they had a lot of lawyers. So the arguments back and forth between the corporations and the lawyers as far as settlement strategy, legal strategy, um, and so on, that could be concealed because that's their personal business. But all of the facts that were asked for had to be turned over. Questions or comments about that? It seems like everything that you discover, everything that you find out during the time that you and the lawyer are working on the case, you might think that that's work product, but it's not work product. Because a lot of what you're finding out are facts that have to come out, that have to be disclosed. Questions, comments on that? Because to me, that's the hardest part of this, especially for your classmates that have not had any exposure to civil litigation before taking this course. Because we're bringing up a difficult matter. Work product is kind of a difficult matter within civil litigation, more so even than ethics. And it doesn't make sense out of context. It does not make sense until you realize that almost everything else has to be turned over. It's a narrow exception. We find out 100 things, and then yes, we can make our notes on how we're going to do things and why. We can make notes on the fact that the client, let's say that the client is willing to settle for $10,000, even though feels that we should ask for $30,000. That's a secret, okay? But the fact that the client has $8,000 of medical bills, that's a secret until we sue on it, and then we have to produce it to the other side. Any questions about that? We're suing for the medical bills, and we have to disclose it in advance of trial. We're not allowed to say, "Oh, we'll give it to you at the last minute if we change our mind. If we decide that we want to." No, we have to disclose it. The same thing with if the other side asks if our personal injured client has ever hurt their knee before, and we're suing for a new damage to the knee, we have to disclose it, even though our trial strategy is that we'd like to conceal it. We're stuck with having to disclose an actual fact. Whether we want to call as a witness and ask lots of questions, what exact questions we're going to ask of the medical expert. That's our notes. What exact questions we're going to ask, but the case facts of what the reports are, we'll have to disclose. Questions, comments about that? It's a subtle matter that judges puzzle over. So if you understand it thoroughly, you are so far ahead of the game. But I want you to understand basics of what it is these judges and these higher court judges and these lawyers are arguing about. Because they are arguing about work product. It's really not super easy, if you ask me. Anything that judges struggle over, I don't expect you to absorb in 10 minutes or half hour or a couple hours. Just not going to happen. Because even if you know perfectly well, some higher court judge will disagree with you, even though other higher court judges agree with you, okay, on how to apply it to a given case. They will disagree. So if you're absolutely sure, then you're probably wrong. If there's a difficult case and you know for sure what the answer is, that's wrong because the answer is uncertain. Uncertainty on the difficult matters. Uncertainty sometimes is the answer. Questions, comments, problems? And of course, a lot of times the paralegal answer should be, here's some from this side and some from this side. And, you say, this side of the issue, and you say cited source. And then you say comments and difficulties, okay? Comments analysis. And then, of course, other side of the issue. And you might not be satisfied with what I'm saying here, but on the difficult matters, when I say difficulties, that involves uncertainty. Uncertainty is not bad when you get to this level of work. Having some level of uncertainty and being willing to put it down on a piece of paper or onto a Microsoft Word document is smart. Okay. Factual work product and mental impression work product. And the materials will help you with that. The only way to figure it out is to look at examples. Examples in the readings. Not super easy. Okay. Mental impression work product is the easier part. Factual work product, you're going to have people argue all day about that because if it ends up being a fact that's relevant to trial, it's normally going to have to be discovered. See, and this is one of the ones that they gave me, but most of this is going to have to be discovered, even though the materials say that it doesn't. I think it does, because you're always going to be able to show substantial need. If you wanted it discovered, if you fight a little bit, you're going to get it, because you're going to say without undue hardship, we want the materials that they have. And the judge is going to favor the party asking for discovery. And I'm stating this based on experience. But if you do some legal research within on 26B3, if you go to federal rule, and you don't need to put all the periods in the right places or use all the capital letters. If you look in Lexis for Fed Rule Civil Procedure 26B3, you're going to see that case decisions are there. And if they fight for discovery, they're going to get it. The thing is, if you interview witnesses, if you're smart, you're going to take statements and then you're going to have to disclose those statements. If you don't disclose them, you won't be able to use the statement if the witness contradicts it. So I would say take statements and then disclose them. I would tell any lawyer that. And paralegal. Prepare to disclose them. Okay. Technically, I suppose you could casually talk to a witness, have some handwritten notes, I don't know why you'd want to do that, but you could. If the witness has basically nothing factual to say, um, I suppose they could try to get you to state what you found out. You find out lack of information or something. I suppose that could happen. Um, but hardly ever have I seen in the practical world. I can't recall somebody refusing to answer a question about witnesses that they interviewed, and then having the judge say, "Oh, they don't have to tell." Have not seen that, but it could happen, I suppose. Um, Perhaps in federal court, the judge could say they don't have to disclose it. But normally they're going to show undue hardship and get it anyway. So factual discovery, um, the practical side of it is to go ahead and keep good records and prepare to turn them over. You know, mental impressions. Um, what we think is our business as a law firm. If you four work for me and all of your classmates that are listening by recording, if you folks all work for me, and I say Shannon, Heather, Chandler, Zaria, what do you think about the credibility of our um, of those three siblings, brother and two sisters that we talked to? What do you think about the credibility? Do you think the jury will believe them? Um, or do you think the jury will think they exaggerated? And you folks give me your opinions, um, and I write it down. Do you think I'll have to disclose that? Does it sound fair that I would have to? No, and it's kind of commonsensical, but in some ways, when you see how broad and sweeping discovery is and how many things have to be discovered, and there's almost no excuses not to turn it over. In that context, you do have to think about it. Well, okay, we took notes and we wrote it down. The lawyer even typed out what we all thought of our various witnesses. Um, my problem on ethics actually with this is I would like to be able to keep this from the client, but it seems to me most states' high courts, my notes belong to the client, and it may be embarrassing to the client. It may be his brother and two sisters, and the five of us think that they're not very believable. Um, I guess I would like to be able to destroy those notes and not turn them over to the client, but I guess some states, and I'll look that up someday, but some states say that even that belongs to the client. I don't agree, but to me, my notes, I should be able to write down and put in a file folder whether I think the client is going to be believable to an objective outsider, and not have to tell the client that because it's very embarrassing. I'm on the client's side, but I have to take into account the way the client appears. Okay. And I represented people with very bad attitudes, and I did not want them to, and in some cases, not with a jury trial, but just a judge trial, and I did not want them to talk to the judge. In other words, testify, because they had bad attitudes. They were good people, basically, and certainly worthy of my best efforts, but they had bad attitudes about the civil matter. Uh, Maybe start partly justified. They felt like the other, they felt resentful about what the other party was doing or not doing, or paying or not paying, for things. Um, and you really didn't want to expose their line of talk to the judge, but it's very delicate. You don't really want to tell the client you're going to look like a turkey and act like a turkey if I let you talk to the judge. Just with the kind of questions you want me to ask. And I had to sometimes explain, your attitude is bad about certain things, and I don't want to ask you those questions. But it's awkward to do that, but my mental impressions definitely did not have to be given to the other side. Even if I kept notes on them, even if I made really nice notes on them, I still don't have to photocopy them for the other side. When you make very frank notes about settlements and possible settlements, strategy, and whatever, you really want to protect those with your life. I'm exaggerating almost none here. We cannot let the other side ever see those. We don't want them to know that we might settle for less or that we might settle for more money or something. That is none of their business. They have to negotiate from their side. We have to negotiate from ours, and that. And of course, here's some big clues as far as assignment is to look up these, Federal Rule Civil Procedure 26B, of course, is a big help, isn't it? 26B, and then Federal Rule of Evidence 502. Those are big clues for you, things to look up. Federal Rule Civil Procedure 26B, and look that up and find the relevant parts in Federal Rule of Evidence 502. Look that up. And your live classroom quiz words are mental impression. I'm sorry, I'm going to have to keep you for a while because there's more to cover. This one is a fairly, to me, this is one of the more difficult assignments. And a lot of times they do come in weeks 3 and 4 too, but communications have been there with the attorney and with you, with the client. Now, you and the attorney, you and the client, there's just as good of a protection as with the attorney and client. Full protection for confidences, okay? May not be primary sources in your state that are easy enough to find, but I will help with them. Old case law having to do with any helper for the attorney. May exist, okay? So there may be old case law, but it's going to be hard to find those things. So I'm going to let you use secondary sources as far as the paralegal privilege, you might say. You're not going to probably find something in your state that specifically says the word paralegal in there, but attorney and client does include attorneys. Attorney, employee, and client, whether paralegal or not, okay? Questions, problems with what I'm saying? In other words, this one part of this assignment that people puzzled over way too much last time I taught this, was they were trying to find a very specific source that had to do with um, confidences or secrets between the client and paralegal. And I'm not going to be able to necessarily help everybody in the class individually, but I will help anybody who wants to if you contact me. Uh, and I will get you a source, but it may be a generalized source. I may use a national or even a secondary source for you just to get you over that hurdle. Okay. So the first problem is don't get stuck on the first problem. Communications between you and the client, you as employee of lawyer, don't get stuck on that and worry so much about finding something particularly paralegal. But you do want case law, statutes, and rules, and primarily we're going to work on those that have to do with attorney, okay? Attorney-client. So privilege, you start with confidentiality, what we worked on last week. Source, which will be a state rule. Yes, Heather asked, it's okay to focus on attorney privilege? Yes. Attorney confidentiality, source, state rule. And then since we have the federal statutes and rule in there, you may use federal and rule for work product. One thing that sort of bothers me about this assignment that I really try to hammer home is that it's not clear from the assignment. If you are totally, if you totally find this easy, I want you to look at the timeline two different ways because it should have two different answers. And I don't know if the person who created the assignment really thought about this. But there's more than one answer. Again, uncertainty is good. When the question has an uncertain answer, then you should be uncertain. Okay. Is the timeline going to be used in front of the jury or used as an exhibit at trial? Or just used as a mental help for the attorney, a memory tool? Who can guess? Let's say that it's just used as a mental memory tool for the attorney whose staff prepared it. Does it have to be disclosed or not? What do you think? The timeline we made, is it a fact? Didn't exist before we did it. It doesn't exist in the outside world, the world of facts. The company didn't do it, or the client didn't do it. The other side didn't do it. An unbiased witness didn't do it. We did it. We created it. So is it a fact in the case? What do you think? Or is it a mental impression? Help me out here. We're almost done. Otherwise, this is kind of the hard part, if you ask me. Yes. Yeah, it's a mental impression, memory tool. It's not a fact in the case. It exists as a file or piece of paper. I understand that, but it doesn't exist in the outside world. It's just part of the legal world that we created for our own law firm. Okay, so it's a mental impression. Um, it's our it's our tool, not everybody's tool. But if we make it um, a tool for the judge and jury, does that change it? In other words, would we then have to disclose it anyway, even though we created it? What do you think? Based on just the generality of what I've been telling you. The whole idea of discovery in civil cases is to avoid any surprise. You're not supposed to show up in a civil case and say, hey, surprise, we got a new witness. We have a new piece of paper. We have a new document. We did an accident reconstruction we didn't tell you about. It's to avoid unfair surprise, which basically means basically about any surprise. So is it discoverable? I will answer that yes. Even though we created it, if we publicly use it, we should have provided it. Okay. As an exhibit. If we intend to use it as an exhibit, we need to discover it. Now, in the olden days when we did things like blackboards and all of that, um, uh, even there, the judge could ask us, or the other side could ask us, are you going to use the blackboard? What are you going to put on there? Because I want to know if I have to object to it or not. You know, that in some cases that was kind of a surprise, but the more sophisticated tools that you use, like a timeline that can be shown, displayed to the jury, that's all done in advance. Um, yes, you have to disclose it. So it seems to me that you should be giving me two different answers for this. Um, but you need to find some, I'm telling you the answers, but you want to find a source. And then you want to find a source. But it's in civil litigation rule. And don't be afraid to ask Lexus help or my help. And I'll put this in the chat. I'll also put it on the whiteboard. And of course, there is also help there's also chat help in Fastcase, which is in the online library. And then librarian help. I announced about librarian help, didn't I? I know I did. I'm going kind of long, but I think it was worthwhile because I want you to really, really feel like you accomplished this, not just that you got through it, but that you accomplished it. You use the motion template and you try to work on case law, statutes, rules. And it's this one. Yeah, so leave the caption as it is. Um, and then fill in the yellow parts law and argument, law and argument, law and argument, okay? Fill in with your own, not your own stuff only, but your own stuff plus the bolstering that you found with the state and federal laws that we talked about. I know I went long, but I think I had to. Thanks for working with me, Chandler, Heather, Shannon, Zaria. Yes. Yep. Yep. It's all for the Module 3 writing assignment. Well, not everything I said tonight, but everything I said about these laws, these statutes, are the Federal Rule of Evidence 502 and the 26B3 of the Federal Rules of Civil Procedure, and then, of course, to get to the equivalent of Rule 1.6 confidentiality of state law.